like to thank all of our panel members today. And now what we'd like to do, we have about 7 minutes remaining. We'd like to give everybody a minute, minute and a half on the panel to go over what they consider the key takeaways. And we would like to do this in the order of the presentations. So we would start with Mary Eaton. Mary, do you have some final thoughts for our audience?
Sure. Thanks again, Sal. With respect to confidential witnesses, I would say that there are 4 main points. The first of which is that particularity is obviously necessary for plaintiffs in crafting a pleading sufficient to withstand the heightened requirements of the SLRA as interpreted by the Supreme Court. But at the same time, the courts that have dealt with these issues to date have furnished plenty of grounds for defendants to challenge those confidential witness allegations to very good effect. So that's the first point I would make. Secondly, although there is no rule about what plaintiffs' counsel should or should not do, at this point there are enough decisions out there critical of certain practices such that plaintiffs' counsel who do not follow the minimum best practices set forth by Judge Engelmeyer are at some risk, at least, of being sanctioned. And so it would be, to the extent that it has not become industry practice, it would be a very good idea for those on the plaintiff's side of the bar to follow Judge Engelmeyer's recommendations. Thirdly, time obviously will tell how the courts are going to resolve the issue of how to deal with recanting witnesses and when it's appropriate to do that. In the meantime, I think that we can expect defendants to continue to raise the issue early for all of the obvious reasons, and we can expect plaintiffs, contrary-wise, to resist those efforts, including on both procedural grounds and on the basis of the fact that the PSLRA imposes an automatic stay, as to which there is at least a certain element of irony. And then lastly, I think in fairness to everyone, especially the witnesses who find themselves quoted in these sorts of complaints, that it would be very beneficial for the Rules Committee at a minimum, and perhaps Congress, to provide much needed guidance in this area. But we'll have to see what happens with that. As to concurrent jurisdiction and subject matter jurisdiction over covered class actions under the 33 Act, as I hope my presentation at least made clear, these issues are very, very complicated, and there is no straightforward answer. To quote Judge Pauley, the statute is an absolute labyrinth. And so it is unclear at this point which way the Supreme Court is going to rule. Secondly, the opportunities for review, even in the meantime, remain very limited. Orders granting remand are generally not reviewable, and orders denying remand are non-filable, and so not appealable until final judgment, at which point they are of limited utility for the defendant side. So we really do need Supreme Court guidance on this issue, which hopefully will come very, very soon. And either way, it's going to have a very significant impact on how these cases are litigated in the future.
Thank you, Mary Eaton. I'm not sure if I issued the sixth secret word, so it's PRICE, P-R-I-C-E, for the attendees seeking continuing education credit. PRICE, secret word number 6. Inez, Alexander, and Matthew, we're really running short on time. If, please, you could take a minute each for some final thoughts. Inez, you go first, please.
Sure. I think that we can expect to see a continued increase in item 303 and 503 allegations in 1933 Act cases, and at least until the Supreme Court resolves the circuit split in 1934 Act cases. So I would counsel defendants facing such allegations to continue to focus on the key defenses, which are the actual knowledge requirement and the requirement that the known trend or uncertainty is likely to have a material adverse effect, or that the risk is among the most significant risks facing the company. On the standing, Section 11 and 12 standing issue, I think that this is I do expect that more and more circuits will adopt the rules that the Ninth and the First Circuit adopted in Century Aluminum and Ariad, and I would just encourage all practitioners in this area to be on alert for the various types of things, purchases on different dates other than the offering at different prices, and not leave that argument on the table. There's a good reason why these cases defendants will typically want them to be in federal court, because a lot of that information appears in the lead plaintiff certification, which generally is not available in actions filed in state court. And then finally, on Calpers versus ANZ, I think that the impact of that case is going to be felt well beyond the 1933 Act. It will be used to try to narrow the application of American pipe tolling in other contexts, especially cross-jurisdictional tolling. And I do think that while it's not likely to unleash a flood of protective actions, we are going to see more opt-outs, and the relatively few class members who are incented to opt out will do so sooner, which will provide defendants, I think, greater certainty as to their maximum liability and may facilitate their ability to negotiate a comprehensive resolution of their exposure.
Thank you, Inez Friedman-Boyce. Alexander Royce.
Yeah, 2 points. One, wonder whether practically and economically the defendants will be happy about all the results of multiple jurisdiction litigation as a result of maybe Vivendi and Morrison. And I will see probably Vivendi's being used more as a defense. We'll see a lot more interventions or other ways of joining actively some class action to avoid this reciprocal argument or lack of reciprocity argument.
Thank you very much, Alexander Royce. And Matthew Aronian, please.
Sure, quickly. I think takeaway is that courts are becoming more critical of the use of the event study. I think it's narrowed the ability of defendants to exploit the opening that Halliburton seemed to afford them. For plaintiffs, they're also facing some higher hurdles, but providing more additional evidence outside of the event study might prove critical to them. So I think when used, the key thing is that you have to be doing this carefully and very transparently, and I think it just makes good sense to consult with an expert early on.